Good morning, everyone. Welcome to Master Stage. And today we are going to discuss about the Tribunal and Court, which is related to the IRC 2020. And it is very important for your examination point of view. And the concepts are clear, clearly given the explanation that will be helpful to you. Okay. So, 2020, and it is a part of LLB uh, third sim, in which we are going to discuss third unit, authorities and miscellaneous provisions. Okay, let us see. Here there are in industrial dispute, there are hierarchies are there in order to solve that particular disputes. So disputes between employer and employee and industrial unrest. So first there is a work committee, then conciliation officer, then court of inquiry, then industrial tribunal. So here the work committee, that means workplace level disputes will be handled. So if the any problem arises in a workplace, then works committee will look after that one. Then conciliation officer, so he mediates between before formal. So he mediate, like, in order to solve their problem, this conciliation officers like facilitate to settlement the issue. Then it goes to the court. Okay. Then it will be like inquire into detailing, then investigation for the industrial dispute. Then the final one is the industrial tribunal. So adjudicate employment conflicts. So it is a final one, the industrial dispute. So industrial relation code, that IRC 2020, established the structure hierarchy of authorities to address disputes at various level, ensuring that efficient and resolution and industrial harmony. So the hierarchy of authorities is that works committee, then conciliation officer, then courts inquiry, then industrial tribunal will comes into picture. So these are the things. Then works committee, so it is established in industrial establishment. Okay. Where employees more than hundreds are there, then equal representation from the employers and workmen. Okay. So work committee constitute minimum 100 peoples are there. Their work committee is going to represent. So the key function is that promote measures for securing and preserving uh, amity, then comment on matters of common interest, then in order to solve their difference, and there's a constructive cooperation will go on. So the limitation, it cannot adjudicate dispute or impose binding decision. That means they cannot judge anything. They want to solve the problems through work committee. In order to establish a harmonious way, 100 plus workers, their union, and uh, the equal representation by the employer. So they work together and they want to solve the issue. Okay. However, they cannot judge, they cannot penalize anyone. So this is the key functions of works committee. Then conciliation process, how it's going to be done. So when the dispute arises, the conciliations officers will appointed by state or government. Then he is going to, or she is going to investigate. Then the parties will meet. The parties means it is employer and employees or laborers. So they should, the conciliation officer make sure that uh, they sit together, and the disputes will be solved, try to solve. The powers of conciliation officer is appointed by the state or government. Okay. So in order to investigate in disputes and circumstances, then the conciliation officer is going to call the both the members from employer side and employees. So they will access exact factory and the related documents, and these conciliation officers help to process conciliation officer helps to solve the dispute voluntarily. Okay, voluntary settlement. So he's going to submit the reports to the government. Okay, if he is unable to uh, like send the documents, at least within 14 days he has to submit the report why he is unable to settle the this particular dispute. So this is the conciliation process. We already discussed about the works committee. Then here, then the third one will go to, kindly be online. uh, Here the next one is limitation to raise industrial disputes. So why these particular limitations happen? Okay, here kindly be online. Okay, so this is the conciliation process with limitation to raise industrial disputes. So sometimes individual different disputes are there within 3 years from the date to cause of action. Then collective disputes within 3 years from the date when the dispute arises. Exception: authority may content delay for sufficient cause. So important limitations that ensure that timely resolutions prevents stale claim, promotes industrial peace, and provide certainty to both the parties. So limitation period computed from the date when the cause of action arise, not from the date of acknowledge. So they'll give the uh, 3 years individual within 3 years that can be caused, action will be taken, and collective disputes within 3 years from the date when the dispute arises. Exceptions: so they may authority may delay for sufficient cause. They will give the time, let the disputes is going to be solved themselves. Okay, then here court of inquiry versus industrial tribunal. So what is the difference between court inquiry and industrial tribunal? The court inquiry, uh, it investigate the matter for public importance. So it is similar to the civil court for evidence. Then the reports advisory, not final verdict. This is a court of inquiry. It is the for the for the favor of public public importance. Then industrial tribunal, so it is it hears, and the disputes will be, after the disputes here they will give the awards or judgment. So they have the industrial tribunal have the full judicial powers. So uh, whatever the award, whatever the final verdict, both the parties, whether it is employer and employee, need to bind that particular verdict. Okay, so the key distinction is the court of inquiry investigates and recommends. Okay, the court inquiry, what happened? Simply they inquire and investigate and recommend the solutions, whereas tribunal, they hear and they have the judicial power, and whatever the final verdict they give, the both the parties need to uh, follow that particular uh, final verdict. So these are the basic difference between court of inquiry and industrial tribunal. Okay, then industrial tribunal versus national industrial tribunal. So we'll see the difference. Industrial tribunal, it is basically uh, formed by the state government. So the jurisdiction of that one in the state level, and particular state only. If it is Andhra Pradesh, it is Telangana or Maharashtra, that particular only. So it handle the matters schedule 11 and schedule 2 and 3. Okay, in IRC 2020, So it will be there one or more state. Okay, maybe one state or two states that industrial tribunal will be there, whereas national tribunal, so it is constituted by the central government of India. So the jurisdiction, the area where it's going to conduct the investigation, it is multi-state disputes is more than two, three, or more states. So if the matter is national importance, so it's cover the state tribunals also. The common power, both the tribunals, that means industrial tribunal and national tribunal, they have the uh, they have possessed power of civil courts under CPC. So they are going to summoning and examine the witness. So they need to have proper documents. Okay, they receive the evidence on affidavits, so issuing the some commissions for examination. So award binding, award are binding all the parties and enforceable as court decrees. That means, so whatever the final verdicts they gives, whether it is industrial tribunal or national tribunal, both the parties, whether it is employer or employee, need to follow the same. This is the industrial tribunal versus national industrial tribunal. Okay, I hope you understand this. Then voluntary arbitration. So it means both the parties comes, okay, whether it is employer or employee, so they comes like arbitration agreement. That means parties mutually agrees to refer disputes for arbitrator. So both the parties comes to the arbitrator mutually, and they will agree one point. So this particular agreement sent to the government for the approval. Then arbitration proceeding. Arbitrator conduct the hearing and examine the evidence. Then award passed. Arbitrate award the same effect as tribunal award. However, this is the voluntary. Okay, both the parties are there. Both the parties agreed to appoint the arbitrate, and this reference is sent to the government for approval. Then advantages. So it is a voluntary. Then it is a faster than adjudication. Then less formal proceeding. Parties choose arbitrator. So arbitration versus adjudication. Arbitration is a voluntary, uh, consensus, and parties select arbiter, whereas adjudication is a compulsory, is government appointed tribunal. So you should remember, arbitration is a voluntary, whereas adjudication is the appointed by the government. It is like a tribunal. Then it goes to the restriction during the pendency of proceeding. So when the conciliation with the tribunal or workmen's goes for this particular resolution, that time some of the restrictions are there during the proceedings. Okay, what is that? Alteration of service condition. So employer, the person who provide the employees, they cannot change the service and conditions without the permission of authority during the conciliation of adjudication. Then protection from discharge. No workman can be discharged or dismissed without approval of the tribunal during the pendency. Management rights. So employers rights to be retained the disciplinary action with the prior approval for the misconduct. Okay, in some cases the employer can take the action with the prior approval of the tribunal. Okay, those who are doing the misconduct. So recovery for money due. When the money is due from the employer under settlement or award, so application made to the authority, certificate issued to collector, then recovered areas of land revenue. So these are the ensure that effective enforcement of workers' monetary rights. So this is a restriction during the pendency of proceeding. Okay, the employer cannot modify the this terms and conditions of the place they work. Then no labor can be discharged or suspended from the work without approval of the tribunal. then management has the right to take the disciplinary action with the prior approval of the prior approval for conducting to take the action. Okay, these are the things. And the work we what we learned today, quick revision, like key points: promotes harmony in establishment with 100 plus workers. Then conciliation officer, they submit the reports if within the uh, 14 days of failure. Then limitation, it is uh, for rising disputes for in 3 years, court inquiry, so gives advisor report, tribunal passes binding award. National tribunal, so which handle the multi-state and national important dispute. Voluntary arbitration requires mutual agreement and government approval. Service and condition, so service condition cannot be altered during the pendency or during the process of hearing. Then discharge and dismissal prohibited, um, like during the proceeding without tribunal approval. Money recover, so enforced through collector or land revenue arises. Unfair labor practices for employers or workmen attract penalties. These are the things. Go through this one. Okay. And this labor law, if you write properly about this tribunal and court, okay, industrial relations code, okay, various hierarchy authorities like works committee, conciliation officer, courts of inquiry, industrial tribunal. Okay, then works committee I explained, conciliation process also I explained. Then limitation to raise the industrial disputes, it's a 3 years. Then we discussed courts versus industrial tribunal. Then we discussed between difference between industrial tribunal versus national industrial tribunal. Okay, then voluntary arbitration. Okay, restriction during the pendency of proceeding. So go through this one. This will be helpful to clear examination without any difficult. I hope you understand this. Okay, and remaining fourth unit also I'm going to post soon. Thank you for listening. We'll meet next video. If you like this content, please do share with your friends and relatives. Okay, so that it will be helpful to you all. All the best for your coming examination.